This first part of the presentation is focused on two key elements of contractual formation, that of offer and acceptance. The law of contract is about the enforcement of promises. Not all promises are enforced by courts, however. To enforce a set of promises or an agreement, courts look for the presence of certain elements. When these elements are present, a court will find that the agreement is a contract. This is a somewhat artificial process. To a certain extent, courts will find that some agreements simply look like contracts and then they reason backwards in order to find the elements necessary to form them. Be prepared, therefore, to be initially confused about the link between the law on contractual formation and the everyday experience of deal-making. To say that we have a contract means that the parties have voluntarily assumed liabilities with regard to each other. The process of agreement begins with an offer. For a contract to be formed, this offer must be unconditional. The law imposes various requirements as to the communication of the offer and the acceptance. Once there has been a valid communication of this acceptance, the law requires that certain other elements that we will talk about later on are present. If these elements are not present, a court will not find that the contract exists between the parties. In the absence of a contract, neither party will be bound to the tentative promises or agreements that they've made. It is thus of critical importance to determine whether or not a contract has been formed. We begin by discussing the nature of a contractual offer. It is important to understand that it is not the subjective intentions of the parties, legal effect of their words or actions, but how these would seem to an external observer. That is to say that the offer is interpreted according to an objective intention. This, in other words, is the interpretation the reasonable person in the position of the offeree would place upon the statement or action of the offeror. This is crucial in answering the basic question of what is an offer. We can say that an offer is an expression of willingness to contract on certain terms. It must be made with the intention that it will become binding upon acceptance. There must be no further negotiations or discussions required. It is very important to realize from the outset that not all communications will be offers. They will lack the necessary intention to be bound upon acceptance. If they are not offers, what are they? At this point, we will distinguish an offer from other steps in the negotiation process. These other steps in the negotiation process might include the statement of intention, supply of information, or an invitation to treat. Let's see a few of those in turn. A statement of intention, where one party states that he intends to do something, differs from an offer in that he is not stating that he will do something. An example is the case of Harvey versus Facey from 1893. Similarly, if one party provides information to the other party, he supplies the information to enlighten the other party. The statement is not intended to be acted upon. An invitation to treat is an indication of a business. It is an invitation to make an offer or to commence negotiations. Courts have considered whether or not a communication was an offer or an invitation to treat in a wide variety of circumstances. A display of goods is generally an invitation to treat, and so is an advertisement, as in Partridge versus Crittenden in 1968. And so is a request for tenders. An auctioneer's request for bids is also an invitation to treat, which means that the bid is an offer. When the auctioneer brings his hammer down, then he has accepted the offer. To be effective, an offer must be communicated in the sense that the offeree, the person who will accept, knows of the existence of the offer. There can be no acceptance of an offer without knowledge of this offer. The reason for this requirement is that if we say that a contract is an agreed bargain, there can be no agreement without knowledge. There can be no meeting of the minds if one mind is unaware of the other. Stated another way, an acceptance cannot mirror an offer if the acceptance is made in ignorance of the offer. The authorities are, however, divided on the need to communicate the offer. We now turn to acceptance. For a contract to be formed, there must be an acceptance of the offer. The acceptance must be an agreement to each of the terms of the offer. It is sometimes said that the acceptance must be a mirror image of the offer. The acceptance can be by words or by conduct. Acceptance occurs when the offeree's words or conduct show to an objective observer that the offeror's terms. If the offeree attempts to add new terms when he is accepting, then this is considered to be a counter-offer and not an acceptance. A counter-offer implies a rejection of the original offer, which is thereby destroyed and cannot be subsequently accepted. See, for example, Hyde versus Wrench from 1840. When the offeree queries the offer and seeks more information, this is neither an acceptance nor a rejection, and the original offer stands. In some cases, the parties will attempt to contract on different standard forms. In this instance, there will be what we call a battle of offers and counter-offers passing back and forth. The Court of Appeal held in the case of Butler Machine Tool from 1979 that the last shot is the one who wins this battle of the forms. The general rule is that acceptance is not effective unless it's been communicated to the offeror. This is sometimes expressed by saying that the acceptance cannot be made through silence. The offeror cannot waive communication because that would be to the detriment of the offeree. The general rule is displaced in the case of a unilateral contract. A unilateral contract is one where one party makes an offer to pay another if that other party performs some act or refrains from some act. The other party does not need to make a promise to do the act or refrain from it. In these cases, acceptance of the offer occurs through performance and there is no need to communicate acceptance in advance of this performance. An example of the offer of a unilateral contract is an offer of a reward for the return of a lost cat, for example. In the case of Carlyle versus Carbolic Smoke Ball from 1893, it was established that performance is the acceptance of the offer and there is no need to communicate the attempt to perform. Communication of the acceptance is waived because it would be unreasonable for the offeror to rely on the absence of communication which would have been unnecessary or which no reasonable person would be expected to make. The rule that an acceptance must be communicated is also waived in the case of the postal rule. The exception was devised in the case of Adams and Linsell from 1818. This puts the risk of delay or loss on the offeror. It is important to remember that the rule is an exception to the general rule requiring communication. As modern forms of communication such as fax and almost instantaneous, courts have shown a marked reluctance to extend the postal rule to these new forms of communication. See, for example, the case of Allianz Insurance from 2008. It is also important to remember that offers do not exist indefinitely. For the revocation of an offer to be effective, there must be actual communication of this revocation. It is not necessary for the revocation to be communicated by the offeror, however. Communication to the offeree through another reliable source will be sufficient. See, for example, the case of Manchester Council from 1970. We now move on to the concept of consideration. This concept is the principal way in which English courts decide whether an agreement that has resulted from an exchange of offer and acceptance should be legally enforceable. It is possible to see consideration as an important indication that the parties intended their agreement to be legally binding as a contract. In exchanges where there is an immediate, simultaneous transfer of, say, goods for money, the doctrine of consideration applies in theory but rarely causes any practical problems. However, it's when somebody says, "I will deliver these goods next Thursday," or "I will pay you £1,000 on the 1st of January," that it becomes important to decide whether that promise is supported by consideration, whether it's taken to mean that something has been given or promised in exchange. A quick way to remember what consideration is about is to think whether in any given transaction there's been a promise to exchange something valuable to the other party. Let us try to define consideration in slightly more concrete terms. In Carey v. Missa in 1875, it was stated that a valuable consideration in the sense of the law may consist either in some right, interest, profit, or benefit accruing to the one party, or some detriment, loss of responsibility given, suffered, or undertaken by the other. English law treats the making of a promise, as distinct from its performance, as capable of being consideration. This consideration must move from the promisee but not necessarily go to the promisor. One could promise to pay a sum of money to a third party, for example. Also, consideration must be sufficient, but it does not need to be adequate. The requirement that consideration is sufficient means that what is being put forward must be something which the courts will recognize as legally capable of constituting consideration. The fact that it does not need to be adequate indicates that the courts are not generally interested in whether there is a match in value between what is being offered by either party. This was established in Chappell versus Nestle. It was said that a contracting party can stipulate for what consideration he chooses. The courts will not interfere just because it appears that the person has made a bad bargain. An area of particular difficulty relates to promises to perform existing obligations. There are three aspects to this topic, dealing with three different types of existing obligation which may be argued to constitute. First, we consider obligations that arise under the law, independent of any contract. An example would be where a public official agrees to carry out some of their duties in return for a promise of payment from a member of the public. In that situation, the promise of payment will not generally be enforceable. See Glassbrook Brothers v. Morgan County Council from 1925. Secondly, we have obligations which are owed under a contract with a third party. For those obligations which are owed under a contract with somebody else, the position is much more straightforward. The courts have consistently taken the view that this can provide good consideration for a fresh promise. The Privy Council confirmed in Pau On from 1980 that the promise to perform an existing obligation owed to a third party can constitute good consideration. Thirdly, we have obligations which exist under a contract with a person who has made a new promise for which the existing obligation is alleged to provide good consideration. These are more problematic. There are two particular cases in this area which are important and you should read them carefully. Stilk and Myrek from 1809 and Williams and Roffey from 1991. Stilk and Myrek was long accepted as establishing the principle that the performance of an existing contractual obligation could never be good consideration for a fresh promise from the person to whom the obligation is owed. The Court of Appeal's decision in Williams and Roffey raised the question of whether Stilk and Myrek could still be considered to be good law. Here we have a change with the introduction of the legal benefit as good consideration. Williams and Roffey has not, however, affected the related rule that part payment of debt can never discharge the debtor from the obligation to pay the balance. This rule does not derive from Stilk and Myrek, but from the House of Lords decision in Fox and Beer in 1884. The Court of Appeal in Reselect Movie 95 confirmed the decision, and we've also got South Caribbean Trading, where it tried to marry the decision in Williams and Roffey with the situation for part payment of debts. In MWB Business Exchange vs. Rock Advert 2016, the Court of Appeal accepted something bringing the idea of practical benefit closer to eroding the doctrine on non-acceptance of part payment of debts from Fox and Beer. This area of the law is still subject to a lot of development. A further rule about the sufficiency of consideration must be given after the promise for which it is given to make it enforceable. This is usually referred to as the requirement that consideration cannot be passed. A promise which is given only when the alleged consideration has been completed is unenforceable. As with many rules relating to consideration, however, there is an exception to this rule about past consideration. The circumstances in which a promise made after the act will constitute consideration has been thoroughly discussed in Pau On vs. Lau Yiu. This part of the presentation is focused on three further basic elements necessary for the formation of contract: that the parties intend to create legal relations, that the terms of the agreement are certain, and that the agreement is complete and does not need any further development or clarification. We start with intention. It is essential that all parties to an agreement have an intention to create legal relations. What this means is that the parties intend that legal consequences attach to their agreement. In short, parties intend that the agreement will be binding with recourse to some external adjudicator, a court or an arbitrator, for its enforceability. The necessity for intention is most evident in domestic and social agreements. Traditionally, the law has distinguished between domestic and social agreements and commercial ones. In the case of domestic and social, it is presumed that there is no intention to create legal relations. In the case of commercial, it is presumed that there is an intention to create legal relations. In either instance, the facts of the case may displace the presumption that the law would otherwise make. In Balfour and Balfour in 1919, you can see a case that establishes a rebuttable presumption that domestic agreements are not intended to be legally binding. A rebuttable presumption is a presumption made by the courts as to certain facts which can be proven to the contrary. An example of a situation in which the presumption was rebutted is the decision in Merritt v. Merritt in 1970. In relation to commercial agreements, the courts will generally presume that an intention to create legal relations exists. See Esso Petroleum from 1976 as an example. An enforceable contract also requires certainty of terms. That is to say, that for an agreement to be a contract, it must be apparent what the terms of the contract are. An important term that is not missing will mean that there is no contract. This is Camel v. Austin from 1941. The underlying rationale for this area of the law can be seen in that if the terms cannot be determined with certainty, there is no contract for the court to interpret, as in Hillas v. Arcos from 1932. And finally, the issue of completeness. To create an enforceable contract, the parties must reach an agreement on all the major elements of their contract. The agreement must, in other words, be complete. There must be nothing left outstanding to be agreed upon at a later date. Completeness is an aspect of certainty of terms. Unless an agreement is complete, the court will be unable to state with certainty what agreement has been made between the parties. If there is no agreement on all of the essential elements of a bargain, then there is no contract.